Honorable Prime Minister, Auntie Barbara, Clive, Comrade Chandrapal, Comrade Nandlall, Comrade Gandhi Prasad, my colleague, Member of Parliament, respected elders, comrades and friends, brothers and sisters, I consider it an honor to have been afforded an opportunity to join the long line of illustrious persons to pay tribute to the legendary Dr. Cheddi Jagan. And I want to thank the administration of the Cheddi Jagan Research Institute for inviting me to perform this grand privilege. My lecture is titled Cheddi Jagan and the PPP's Contribution to Electoral Democracy in Guyana through Litigation and Consequential Legal Reforms. Much has been written and said about Dr. Cheddi Jagan, the avowed Marxist theoretician and practitioner. This has evoked as much commendations as it has evoked controversy. However, what is not often written nor said of and about Dr. Jagan is that his was a Marxist orientation and outlook with a unique difference from others of a similar ideological mold. Dr. Jagan passionately embraced the concept of a constitutional democracy constructed upon the axis of separation of powers, respect for the fundamental rights and freedoms of the citizen, and a government elected by fair and free and transparent elections at periodic intervals. Indeed, almost the entirety of his political life was dedicated to the pursuit of these objectives. This singular attribute puts him in a class and a category of his own. It is this facet of Dr. Jagan's politics that will be the focus of this discourse, with particular emphasis on his and his party's contribution to electoral democracy in Guyana through the vehicle of the law and litigation. The greatest legacy of Dr. Jagan, in my view, remains the political party that he birthed on the 1st of January 1950, the People's Progressive Party. It is this party that became the vehicle used in the traverse of his almost every pursuit, including the area that is the subject of my presentation. Electoral irregularities of a formidable nature raised its ugly head for the first time in independent Guyana at the 1968 general elections. The shrewd and Machiavellian political animal that he was, after ousting United Force as a coalition partner in government, Forbes Burnham formed the opinion, and rightfully so, that he could not have won a free and fair election at the 1968 polls. Hence commenced the nefarious and destructive journey of rigged elections in independent Guyana. A journey as history has recorded it to be the most destructive course of action in the modern history of Guyana. With the benefit of hindsight, it is clear that the political directorate in the government of the day decided to use the voters' list as the mechanism to corrupt the 1968 elections. Shortly after the Governor General's proclamation dissolving Parliament and fixing a date for those elections, a power now resident in the Executive President of Guyana, the Chief Elections Officer of the time promulgated a number of regulations under the National Registration Act 1967 to permit the registration of overseas Guyanese on the electoral roll for the purpose of voting in the 1968 elections. The intended mischief of these regulations was quickly identified and a legal challenge was launched. At this juncture, it is opposite that I observed that the Elections Commission of that time comprised of 3 members, including the chairman. The appointment mechanism was as follows. A, the chairperson was appointed by the Governor General upon the advice of the Prime Minister. B, 1 member was appointed by the Governor General upon the advice of the head of the list that commanded the most seats in the National Assembly in the last held elections. And thirdly, the 3rd member was appointed upon the advice of the party that secured 5 or more seats in the National Assembly. In that configuration, the government of the day was responsible for the appointment of 2 members on that commission, the chairman and the 1st member, and the 3rd member would have been a nominee of the People's Progressive Party. Coincidentally, for the 1968 elections, the nominee was Comrade Cheddi Jagan, the wife of Dr. Jagan, and a leader of the People's Progressive Party. The aforementioned legal challenge was launched by an elector, Gladys Petrie. The case is reported in 1968, 14 West Indian reports. This case, in my humble view, began the evolution of modern election case law in Guyana and the Caribbean. Today, half a century later, this case continues to be cited with amazing yet predictable frequency in almost every court in the Commonwealth Caribbean whenever there is a legal challenge to elections. The case was launched by the United Force, obviously aggrieved by its recent expulsion from the then government. Significantly, however, though there must have been strained relations between Dr. Jagan and the leadership of the United Force for obvious political reasons, Dr. Jagan and the PPP supported the United Force in the litigation, recognizing that it was in the nation's best interest to do so. Apart from the Chief Elections Officer, every member of the Elections Commission, along with the Attorney General, were named as respondents. Cheddi Jagan was represented by Derek Jagan, the brother of Dr. Cheddi Jagan. Derek supported the case file, which was being presented by Mr. Joey King. Sir Sridat Ramphal, the Attorney General at the time, appeared, along with Dr. Mohammed Shahabuddin, the Solicitor General. Chief Justice Bullers was assigned the case. With the hindsight of history, it is quickly realized that this was an impenetrable combination of forces aligned. The litigation launch was in the nature of a civil claim. At that time, the law was already settled in jurisdictions such as India that the challenge to an election must be done by an election petition, since the jurisdiction to hear the settlement of an election dispute was a jurisdiction once held by the House of Commons in the United Kingdom, which was transferred to the High Court of England. As a result of this special historical evolution of this jurisdiction in the High Court, specific rules were handed down in terms of how this jurisdiction should be exercised. In Guyana, this dispensation found expression in the then Guyana Constitution and the House of Assembly Validity of Elections Regulation 1964. In the case itself, Chief Justice Bullers, in his written judgment, stated as follows in terms of giving a historical explanation for the evolution of the jurisdiction. I quote, this is Bullers speaking. In Erskine May's Parliamentary Practice, 17th edition, page 184, the learned author points out that before the year 1770, controverted elections were tried and determined by the whole of the House of Commons as mere party questions, upon which the strength by contending factions might be tested. In order to prevent, however, perversion of justice, the House consented to submit the exercise of its privilege to a tribunal constituted by law, which, though composed of its own members, should be appointed to secure impartiality and administration of justice according to the laws of the land and under the sanction of oath. Subsequently, there was a system of selection by lot of committees for the trial of elections petition. Partiality and incompetence, however, continued in the constitution of these committees, and in 1839 an act was passed establishing a new system whereby the responsibility of individual members was increased. Eventually, in 1866, the jurisdiction of the House in the trial of controverted elections was transferred by statutes to the courts of law. Blackstone, in his commentaries, speaking of the unwritten or common law, distinguished the law into three kinds, the third category of which was certain particular laws which by customs are adopted and used by some particular courts of petty, general, and extensive jurisdictions. The history of the laws relating to controverted elections, however, reveals that they were administered by the House of Commons in the exercise of its privilege and not considered by courts, far less adopted until the jurisdiction was transferred by statutes to them. It will thus be seen that from ancient times the courts exercised no common law jurisdiction in relation to elections petition, these being dealt with by the committee selected from the House of Commons, and when the courts did commence to exercise jurisdictions in those matters, it was conferred on the courts by statute passed in the legislature. Unquote. So here, Chief Justice Bollers was tracing the whole history of how the High Court now has a jurisdiction to try elections dispute, and is alluding to the historical fact that it was once a parliamentary function, that Parliament after a while felt that it was incompetent to deal with such a dispute because you have partisan interests in the Parliament, as well as the lack of legally trained personnel to administer disputes in accordance with law. And it was therefore decided that that jurisdiction must be passed in a special way by a special law over to the High Court, and thereafter the High Court, in the exercise of that special jurisdiction, must hear and determine election dispute. More on the special nature of this jurisdiction will be elucidated later, but at this stage it would be fair to say that the method of challenging an election, the special nature of the court's jurisdiction to determine such a challenge, and the rationale for the special nature of the jurisdiction were all by that time matters of settled law. In this regard, the following sentiments were expressed by Bollers' Chief Justice. In conclusion, I quote again, in conclusion, I would refer to the judgment of an Indian case and endorse the view therein expressed, that having regard to the important functions which the legislature have to perform in democratic countries, it has always been recognized to be a matter of first importance that elections should be concluded as early as possible according to time schedule, and all controversial matters and all disputes arising out of the elections should be postponed till after the elections are over, so that the election proceedings may not be unduly retarded or protracted. I hold that the preliminary objection taken by the Attorney General is sound, and I would decline jurisdiction. And I will explain now what happened as the case unfolded. So far, so good. Where the controversy arises is what acts or omissions are so, where the controversy arises is what acts or omissions that are so proximate to the elections themselves that would constitute a challenge to those elections. Here, that is in 1968, the date for elections were already fixed. This was a civil case filed at a minimum 2 months prior to the elections. The thrust of the challenge was directed to the manner in which the voters' list was being compiled. The complaint was that the compilation of this list was done fraudulently, as there were no checks and balances in relation to overseas voters' registration. Injunctions were sought to restrain the elections from being held until the challenge to those regulations that authorized the compilation of that list was heard by the court. In my view, it was open for a court to determine this dispute, as it was a mere matter of law than evidence before elections day, or to recognize that the issues raised are so fundamental to a fair election that its determination would have been the sine qua non to a fair election. Rather than confront the proverbial bull by the horn and determine the issues, the court accepted the arguments of Dr. Shahabuddin and determined the matter to be an election dispute, thus laying down the law, perhaps for the first time in the Caribbean, that any challenge to anything done in the electoral process from the date of the proclamation to the declaration of the final results of an election constitutes an election challenge and must be brought only by an election petition invoking the special jurisdiction, and only after the declaration of the final results for the elections. And I pause here. So what Dr. Shahabuddin got the court to accept was that anything done from that date of proclamation where the election is fixed, any irregularity that happened from that date to the declaration of the final results, you're talking about a 3 months period minimum under our law. Anything that happened there will be regarded as an election dispute and can only be determined by an elections petition after the declaration of the final results. And that is how the law was laid down in Guyana, and the rest of the Caribbean has followed suit, borrowing from the jurisprudence expounded here. And I am saying, at that time, this was not the position. This case laid down the ambit, that broad ambit, as to when or what will constitute an electoral dispute and the time frame within which that act, once it takes place, becomes an election dispute. And that was the broad parameters set by Chief Justice Bollers. As a result, the legal challenge was dismissed because they held it to be an election dispute. So a perverted voters list was allowed to be constructed, unchecked, and that laid the foundation. But I'll go on. As a result, the legal challenge was dismissed. It is important to note that this, being a civil case, was appealable all the way to the Privy Council, at that time Guyana's apex court. Now I pause here to say that an election dispute by an election commission, by an election petition, at that time under our law, had no right of appeal to the Privy Council. But the lawyers of the day did not frame their action as an election dispute because it was prior to the elections and the law was very new in that period. So this was an ordinary civil claim that could have found its way all the way to the Privy Council if it was allowed to go up the court system. This reality did not elude the crafty legal minds of Messrs. Burnham, Ramphal, and Shahabuddin. It is my considered view that it is as a result of the fear of an appeal traveling to that court with the possibility of blocking rigged elections in Guyana that ultimately resulted in the abolition of the Privy Council from Guyana's legal system. It is now a fact of public notoriety, supported by indisputable empirical evidence, that the 1968 elections were massively rigged by the use of the very regulations intended to register overseas voters, which were the subject of challenge in the Petrie case. We have seen the documentary showing that thousands of persons purportedly voted in the United Kingdom whose identity could not have been verified and whose addresses were actually cemeteries in various parts of England. This litigious journey commenced at the 1968 elections, resumed on the eve of the 1973 elections. This time, Dr. Jagan and the PPP took the lead in the legal challenge. C. Kumar Singh was a member of the PPP from the Campbellville PPP group at the time. Again, the challenge was against Chief Elections Officer R.C. Butler. Again, it was filed by C. Kumar Singh, sorry. Again, it related to a challenge against the laws and regulations that permitted postal votes in Guyana, postal voting in Guyana, overseas voting, and the counting of these votes at places different from the places designated by the law. So after the big fallout of the 1968 elections, they realized that they have to alter the game plan a little. So less reliance is going to be placed now on overseas voting. But they introduced two new elements now: postal voting even within Guyana, and though the law specified designated places for the counting of the ballots, the regulations specified counting at certain identified places under the hand of the Chief Elections Officer. Are these things that are bringing back fresh memories to you right now? This is happening in 1973, the year that I was born actually. It is clear that as a result of the public exposure of the fraud perpetrated by alleged overseas voting in the 1968 elections, new strategies were now being pursued in the 1973 elections, namely local postal voting, counting of the votes at places that were not legally designated as counting stations, and the persistence with overseas voting. To the legal challenge, Dr. Shahabuddin appeared as Solicitor General, and again, Chief Justice Bollers was the judge. I am not going to make any cast any aspersions, but you are intelligent people, and you know the role that Chief Justice Bollers played at a later stage in a different incarnation. Again, these offensive regulations were promulgated after the date was fixed for those elections by a proclamation. By this time, appeals to the Privy Council were already abolished. They were abolished in 1970. This is 1973 elections. Now, with the benefit of experience, supposedly greater research conducted, and in a judicial environment from which the Privy Council is absent, the legal excursion commenced in the Petrie case 5 years prior, enjoyed greater amplification and bravado. And it was authoritatively settled that no electoral process may be challenged once the day has been set for election, other than by way of an elections petition filed after the declaration of the results of those elections. That second case cemented the position. Further, the peculiar rules and regulations and the strictness of their adherence were elaborately set out. It is this corpus of judicial pronouncements coming from these two landmark cases that authoritatively settled the law in relation to the challenge of an election. They have been invoked and applied in every challenge filed against an election in Guyana since. Expectedly, the legal challenge in Sikumar case was again dismissed. Again, with the hindsight of history, I can assert with certainty that the 1973 elections were massively rigged using the very regulations and laws that were the subject of legal challenge by Dr. Jagan and the PPP. We know that in those 1973 elections, the Guyana Defense Force, no disrespect to Major, sorry, not Major, Guyana Defense Force descended upon polling stations and took away ballot boxes. Some were later found floating down various rivers in Guyana. Of course, the PNC declared themselves the winner of those elections by a significant margin. At number 64 Village Quarantine, two activists of the People's Progressive Party, Jagan Ramesar and Boladat Parmanan, were shot and killed by our army officers as they attempted to prevent the removal of ballot boxes from the polling station. In 1985, there is no doubt again that the Desmond Hoyt administration massively rigged those elections. The PPP obtained a mere 8 seats. Indeed, the fraud that tainted those elections were greater than any of the previous elections. Again, these elections were challenged, this time by way of an election petition. The PPP was at the forefront of this challenge. Applying the cases of Petrie and Sikumar Singh and the learning expounded thereof in relation to the rigidity of procedural requirements touching and concerning an election petition, this petition was dismissed for non-compliance with those technical requirements. The case to which I refer is reported as Payne against Hammond, number 206 of 1986. On approach to the 1992 elections, it is Dr. Jagan and the PPP, through persistent litigation that led the struggle of democratic reforms eventually implemented, and which brought free and fair elections to Guyana on the 5th of October 1992, after 28 years of perverted elections. Capitalizing on the valuable lessons learned over the years of struggle, including actions in the court system, Dr. Jagan and the PPP successfully canvassed for a reconstituted elections commission, the presence of international observer teams to observe elections, and counting of the ballots at the place of polls, among other things. Statutory and constitutional reforms were effective to bring about these changes. Those elections were observed by international and national observers and declared to have been free and fair. The rest is well-traversed history. So at every step of the way, Dr. Jagan and the PPP were the juggernauts of modern electoral democracy in Guyana. Democratic electoral reforms continued progressively, both at the level of the Constitution and more so via legislation under successive PPP governments, and they continued after the death of Dr. Jagan. Election-related litigation did not cease, despite the restoration of electoral democracy. An elector, Esther Pereira, filed an election petition challenging the 1997 elections. The challenge was on two grounds. One, that there were massive irregularities on election day, denying voters the right to vote. And secondly, there was a challenge to a law which mandated the use of an ID card as a qualification to vote. This challenge was filed by the PNC. The law that they challenged was one with which they agreed and supported when it was passed in the National Assembly. The petition was heard and determined in its entirety. It was the first petition ever fully tried and determined in Guyana. It is no coincidence that the PPP was the government of the day. I cited several election challenges to elections. They were all dismissed. Here you had an election trial for the first time. And I'm going to expand upon that as I continue. The challenge relating to electoral irregularities was dismissed. The argument that the law was unconstitutional was upheld. Though the electoral process was not impugned, the elections were set aside by the judge and fresh elections ordered. This would constitute the first time in Guyana that an election-related litigation was determined by the judiciary against the government of the day. That, in my view, is to the credit of the People's Progressive Party civic government. It means that there was freedom from fear, there was no judicial manipulation and interference. And the law, as the judge saw it, prevailed. And the judge felt courageous enough to rule against the government of the day. The judge would appeal during the tenure of a PPP government. And upon retirement, held 2 posts under PPP governments. This judge was eventually appointed as chairperson of the Elections Petition and Elections Commission with the support of the PPP and still hold that post. The democratic credentials of Dr. Jagan and the People's Progressive Party, and it illustrates its role in Guyana's evolving democracy. This must be compared with an election petition filed by the PPP against the 2015 election, of which APNU-AFC was declared a winner and formed the government. Without attributing any ulterior motive to any person, the fact is that to date, that election petition never made it to trial during the tenure of the government whose purported victory it challenged. Now it is dead and buried, having been overtaken by time and events. Between 2015 to 2020, once again, electoral democracy, the constitution, and the rule of law were placed on trial. No one can dispute that the PPP led the struggle, defending, preserving, and advancing these concepts so vital for economic progress and social advancement in any society. Apart from political agitations in the National Assembly and across the country, the court became a political battleground as never before. Dozens of challenges were filed to protect the constitutional rights and freedoms of our people. Almost every one of them successful. This very Red House was the subject of an unlawful edict by President David Granger to confiscate it by an unlawful termination of a 99-year lease. 1 day notice. It was successfully challenged. The cases filed are too numerous to mention. My focus will only be on those of an election nature. Not unexpected, a plan was hatched to rig the 2020 elections. The Guyana Elections Commission was identified as the vehicle to do so. President Granger, in an unprecedented occurrence, rejected 18 names of outstanding Guyanese submitted to him by the leader of the opposition, Mr. Bharat Jagdeo, General Secretary of the People's Progressive Party, for consideration to be appointed chairperson of GCOM. He then proceeded to unilaterally appoint one of his own liking. The reason was painfully obvious. By so doing, a formula that had worked for 3 decades and birthed out of an arrangement between President Desmond Hoy and Dr. Jagan and brokered by US President Jimmy Carter was subverted. I challenge the appointment in the name of the executive of the PPP, Zulfikar Mustafa. We lost in the High Court and the Court of Appeal. The Caribbean Court of Justice, however, declared the appointment illegal and unconstitutional. In so doing, they brought necessary clarity to that appointment process. However, before the chairman departed, he started an unlawful house-to-house registration exercise. The purpose was to create a defective voters list, going back straight back to 1968. The intention was to scrap the existing database and to implement a new one based upon this registration exercise. Again, the PPP challenged this process in the court. We were vindicated. The court held that persons already registered and whose names were on the list cannot be removed from that list. Then came the no confidence motion. That registration process, as you know, was aborted when the new chairperson of GCOM was sworn in after we won the case. Then came the no confidence motion. It was tabled again by the PPP. It was passed on the 21st of December 2019. The government challenged its legality on two grounds. Firstly, that it was not properly passed because 33 votes used to pass it did not constitute a majority required for passing such a motion in a 65-seat National Assembly. And secondly, that Charan Das Prasad, who voted from the government benches in support of the motion moved by the opposition leader, was disqualified from being elected to the National Assembly under the Constitution as he was a citizen of Canada and therefore his vote was an invalid one. Significantly, this challenge was sponsored by the government of the day. I pause here to say that they put Charan Das in the parliament the same way that they agreed and passed that voters' ID law for the 1997 election, then turned around and challenged it. They put Charan Das in the parliament. They knew that he was a Canadian citizen. And when he cast the vote against them, they turn around now and want to rely upon their own illegality and use that as a basis to invalidate the vote. The then Attorney General paid 2 lawyers who filed the challenge in the name of a citizen, Compton Reed. The plan was that the Attorney General would have appeared in the court and consented to the challenge. This is a guy who's paying 2 lawyers to represent a man to sue him. And the grand plan in his fanciful brain was that he will turn up in the court and consent to judgment, and that will be the end of the matter. The PPP, in the name of its General Secretary, intervened. And so did other citizens. The case went all the way to the CCJ. Our arguments were upheld. The very principles, and I want now, this is where the law is such a karmic force. Now, all the law that they benefited from in Petrie and C. Kumar Singh, you will see now, those very cases that kept them in government, the role that those cases now being applied by the current crop of judges, what those very cases did to them. The very principles enunciated in Petrie and C. Kumar Singh 50 years earlier were invoked to preclude a challenge to Charan Das's election to the National Assembly. Adopting the principles in those cases, the CCJ upheld our submissions that his election ought to have been challenged by an election petition within the time prescribed for the filing of such election after the election in which he was elected. So we have come a full circle. Indeed, the very principles used by the PNC against the PPP in those two cases are the principles that defeated them over 5 decades later. Fast forward now to elections held on 2nd of March 2020. After realizing that they lost those elections within 24 hours after the close of poll, the APNU AFC, in conspiracy with functionaries of GCOM, proceeded to execute one of the most bizarre series of attempts intended to pervert the results of those elections. They first attempted to get the returning officer Region 4 to declare false results from a spreadsheet rather than from the statements of poll which contain a summary of the ballots cast. The PPP rushed to the High Court and obtained orders directing the returning officer to use only the statements of poll as the basis for the tabulation of the votes. The directions of the judge were ignored. The judge made those directions. The directions of the judge were ignored. The returning officer proceeded with his fraudulent design to declare falsified results. Another legal challenge was filed. As it was being heard, and this was a Saturday, at Providence Grove Magistrates Court, because suddenly the High Court was fumigated, and there could have been no sitting of the High Court. A Saturday morning, the court was held at Grove Magistrates Court on the east bank of the Mohabir. As the case was being heard, a decision brokered by CARICOM between the leader of the opposition and then president, a national recount of the ballot was agreed upon. Despite this agreement, the APNU challenged the national recount, the decision or the agreement for the national recount to their candidate, Yulita Moore. They lost in the High Court and the Court of Appeal. Again, the PPP was at the forefront of this litigation. The dismissal of the appeal by the Court of Appeal paved the way for the recount. The recount was conducted. It was observed by a CARICOM team, the only observer team permitted by the government. The results of the recount coincided with the PPP statements of poll, which were made public, and confirmed that the PPP had won the elections. The APNU AFC refused to accept the results of the recount. Instead, they made baseless and reckless allegations of irregularities and illegalities. The CARICOM team, however, in its report certified the recount and the results flowing therefrom as credible, accurate, and reflective of the will of the people. The APNU AFC, through Eslyn David, challenged the result of the recount on several grounds, including a contention that the result included invalid votes. In this case, the intent was to exclude approximately 160,000 votes from being counted. Again, the PPP intervened and led in the defense of the recount process. Again, the matter ended up at the CCJ. Again, the CCJ upheld the PPP's arguments. Again, the CCJ invoked the pronouncements made over 5 decades ago in Pitri and C. Kumar Singh to the effect that such a challenge can only be made by way of an election petition after the declaration of the final results. Despite these clear pronouncements, the Chief Elections Officer refused to use the recount results as the basis to tabulate the final result. The APNU AFC went to court again in the name of Messenger Jones to challenge the validity of the order which their commissioner at GCOM had a hand in drafting and whose validity they accepted in the Eslin David case. They are now challenging the order that authorized the recount to take place. Recall, when the agreement was made to do the recount, GCOM issued an order. This order was negotiated and crafted for weeks at GCOM. It received the unanimous approval of GCOM. The commissioner sat there. And now that they have lost, after the recount is completed, as is the norm, as the precedent that I've cited so many times, they want to turn back the clock now. And they challenge the very thing that they agreed to. Again, they lost, both in the High Court and the Court of Appeal. Again, the cases of P3 and C. Kumar Singh, among a host of others, came back to haunt them. Both courts ruled that they must make their challenge by an election petition after the declaration of the final results. After 5 long and torturous months, and after a tremendous amount of national, regional, and international pressure, and a series of court decisions in which the PPP with others led the struggle, the election results were finally declared and a lawful president was sworn in on the 2nd of August 2020. In the end, democracy and the will of the people prevailed. The rule of law and the people won. While the outstanding contributions of so many persons and organizations must be acknowledged, it cannot be disputed that it was Dr. Jagan's PPP that was the vanguard of that struggle. 2 elections petitions were filed thereafter. Both were dismissed. The grounds for their dismissal were based upon the very principles stated again in the cases of P3, C. Kumar Singh, and Payne and Hammond. Cases decided in favor of the PNC in bygone years. In Payne and Hammond, for example, the election petition was dismissed on the ground of failure to comply with procedure. The PNC benefited from this ruling. It is this identical ground upon which their petition filed by Monica Thomas, election petition 99 of 2020, was dismissed. The breach of their procedure here was that they omitted to serve the petition within the time prescribed by the election rules on no other than David Granger, the head of their list. Again, we have come a full circle. I hope that I've painted a clear enough picture to represent the role that Dr. Jagan and the PPP played and continues to play in the evolution and development of our election law, with particular emphasis on immigration. The learnings that have emanated from these cases represent the modern jurisprudence in this area of the law, not only in Guyana and the Caribbean, but indeed the entire Commonwealth. Most of these cases to which I have made reference are reported in Guyana law reports, the West Indian law reports, and Commonwealth law reports. They will continue to guide judges, legal practitioners, and indeed citizens of Guyana and these various territories whenever electoral challenge arises. In this regard, Dr. Jagan and the PPP's contribution will remain forever indelible. I thank you very much.